California law requires both parties in a divorce to complete financial disclosures. This involves filling out and exchanging forms that detail each party's financial situation, including assets, debts, income, and expenses. These disclosures are necessary for ensuring fair and informed decisions regarding the division of assets, spousal support, and other financial matters. A financial disclosure in a divorce involves completing multiple key forms, including FL 140, FL 141, FL 142, FL 150, and sometimes Form FL 160. It requires you to specify ownership and indebtedness for each asset or debt, the acquisition date, and an estimated value for each item. In addition to these forms, you will need to provide a clear picture of your income, debts, assets, and financial accounts through the use of documents such as paycheck stubs, tax returns, mortgage statements, vehicle titles, property deeds, and statements from all of your financial institutions and investments. These documents must be organized in a clear, complete, and truthful manner. You are then obligated to share these financial disclosures with the opposing party. However, only Forms FL 141 and FL 150 need to be officially filed with the court. During the divorce proceedings, two separate sets of financial disclosures are mandated. The initial set is known as the Preliminary Declaration of Disclosure, and the subsequent one is termed the Final Declaration of Disclosure. The Preliminary Declaration is compulsory and cannot be waived. The law requires each party to submit their financial disclosure within 60 days of filing their initial divorce documents. Additionally, the final financial disclosures must be submitted at least 45 days before the trial begins. This is to ensure that all proceedings are conducted with a clear and transparent understanding of each party's financial situation. Failing to complete financial disclosures prevents finalizing a divorce and may result in sanctions, fines, or losing undisclosed assets. In California, both parties must provide financial disclosures, and a divorce cannot proceed until the respondent completes theirs. You can request the court to order your spouse to comply, and in some cases, the court may waive the requirement to move the case forward. If the respondent fails to provide disclosures, they may face sanctions and be barred from presenting evidence about their assets and debts. If you find inaccuracies or omissions in your spouse's financial disclosure, the first step is to pinpoint the specific areas where the information is lacking or incorrect. You should then request that your spouse provide the necessary corrections or additions to the disclosure. Should your spouse continue to fail to provide accurate and complete information, you have several alternatives available, such as initiating formal discovery procedures or petitioning the court for orders to compel compliance. In rare and extreme cases, a judge may allow a party to waive the right to the other spouse's financial disclosures. This typically happens when continued non-compliance significantly delays the proceedings, and it becomes necessary to move the case forward to avoid undue prejudice to one party. If a judge allows a party to waive their rights to financial disclosures in a California divorce, they would typically need to fill out and file a Stipulation and Waiver of Final Declaration of Disclosure, Form FL 144. Waiving the right to a final declaration of disclosure carries significant risks, including the risk of making uninformed decisions. Additionally, if a party later finds out that assets were hidden or undervalued, and they had waived their right to disclosure, it could be more difficult to contest the division of assets or debts. While there are legal remedies for addressing fraud and deception discovered after a divorce settlement, pursuing these remedies can be legally complex and costly. Moreover, once a waiver is approved and incorporated into a court order, it becomes part of the final divorce decree, which is legally binding. Financial disclosures in divorce are essential for facilitating fair and well-informed decisions related to asset division, spousal support, and other financial aspects of the divorce. Waiving financial disclosures, especially in a community property state like California, should be considered carefully. It is typically not advisable, especially in complex cases or where there is a lack of trust or transparency between the parties. If you need a divorce attorney in Los Angeles or Orange County, California, don't wait. Call Jafari Law and Mediation Office to secure your consultation and take the first step towards a fresh start.